Good morning. Happy Monday. So I did a live stream last night where I went over Springer's response to the court's order to show cause. And this is on Springer versus the 7th Judicial District Court. And so they have two real positions. The court asked them to show cause on three: judicial immunity, why judicial immunity would not prevent the court from hearing the case; why sovereign immunity in the case of the fourth cause of action against the 7th Judicial District Court itself wouldn't prevent the court from hearing that; and finally, why Springer didn't fail to state a claim. Even if judicial immunity does not apply, why Springer didn't fail to state a claim on the causes of action against the judges and their staff. So Springer's response essentially was on the last part, on the failure to state a claim part. Springer's position was, hey, you know what? I'll amend my lawsuit, my complaint, to say that we're suing the judges and their staff in their official capacity. Which, sure, that would help, but Springer's still asking for declaratory and injunctive relief, and the court can't grant injunctive relief to Springer unless he can show that declaratory relief is unavailable, or that a declaratory decree has been basically ignored by the defendants. And he can't show either, so that's bad. So then he goes into the judicial immunity part. He cites a case, a United States Supreme Court case from 1980 that essentially was talking about the Supreme Court of Virginia in its role as not only creating laws to apply to attorneys, because the Virginia legislature said, Supreme Court of Virginia, you get legislative rulemaking over attorneys. You get to create the rules for attorneys. So the Virginia Supreme Court acted in a legislative capacity where it had legislative immunity. It has judicial immunity for judicial acts, but it also was the enforcement arm of the state bar. It is, I'm phrasing that wrong. The state bar can do stuff, but the Virginia Supreme Court enforces its rules on attorneys, because attorneys, we have to be licensed to practice. If the Virginia Supreme Court says you can or can't have a license, it's acting as an enforcement mechanism. The court phrased it differently. Essentially, the Virginia Supreme Court or its lower bodies can sua sponte, say, we want to sanction you, then a prosecutor would take over, yada yada. But the United States Supreme Court said essentially that the Virginia Supreme Court was acting in an enforcement capacity. Now, enforcing of judgments. So why doesn't that apply to every judgment or every order? Well, because courts don't normally enforce their own judgments or orders. Normally, like if you get a civil judgment against somebody, you have to enforce the judgment. You have to get like the marshal or the sheriff or whoever would go out and do the wage garnishment, do the till tap, do the bank levy, whatever it is. The law enforcement would enforce the order of the judge. And so judges normally aren't acting in an enforcement capacity. And in Springer's case, the judges made an order, but they're not the ones who are going to be enforcing that order. It would be the sheriff that would be enforcing that order, if that makes sense. So it doesn't make any sense, the argument. And the case was from 1980, which was prior to the Congress amending 42 USC 1983 to specifically prevent what the United States Supreme Court held in Supreme Court of Virginia versus Consumers something USA Incorporated. I forget the actual name of the case, but the Congress changed what 42 USC 1983 allowed, specifically stating in 1996 that you could only get declaratory relief. And if declaratory relief wasn't available, only then could you get injunctive relief. So injunctive relief is only available if declaratory relief is unavailable, essentially. So that invalidated the portion of that prior Supreme Court, the 1980 Supreme Court case. So why Springer's attorney is relying on it, I don't know. It seems pretty amateur hour, if you ask me. And the third part was the part that I thought maybe they had a minor argument for, because it seemed like there were some cases that were saying, yeah, it's okay, and some cases were saying, no, it's not okay. But the sovereign immunity. So New Mexico has waived sovereign immunity in certain cases under certain conditions. And one of those conditions is that a New Mexico Civil Rights Act lawsuit has to be filed in a New Mexico state district court. It can't be filed in the federal district court for the District of New Mexico. It has to be filed in a New Mexico district court. For example, Springer is suing the 7th Judicial District Court of New Mexico. It's a New Mexico district court as opposed to a federal district court. The New Mexico Civil Rights Act needs to be filed in a New Mexico state district court. So I did a modicum of research after I went off the live stream, and there is no 10th Circuit opinion on it, but all of the district court decisions that deal with sovereign immunity for the New Mexico Civil Rights Act have all come to the same conclusion, and that conclusion is it has to be filed in the New Mexico State District Court. Sovereign immunity prevents the federal district court from hearing a New Mexico Civil Rights Act case. So he struck out on that. Springer's attorneys failed to. They actually literally stated that it applied as long as it was filed in a New Mexico district court, not realizing apparently that when it's a New Mexico district court, it's not a United States district court. A New Mexico district court is not a United States district court. Again, as Ehline seems to have such a hard time understanding, words have meaning. Speaking of Ehline, our alpha male took down apparently a second video. He took down his cringe video where he was in a bar essentially trying to suck off Marines to get them to say that he was, in fact, a Marine, and where he was motherfucking me to people who don't even know who the fuck I am, which is weird. Again, it's really weird. Why an alpha male would have to find other people essentially to justify his actions. I mean, I guess for Ehline, words don't have meaning, and alpha male does not mean alpha male, because he is literally going to other men and saying, please take my side in this online beef with Merb, with a first-year family law attorney. Another weird thing is that he's threatening me, apparently. He's going to drive 3,000 miles. Last time I checked, it wasn't 3,000 miles from Houston, wherever in Texas, to Placer County. That's not 3,000 miles, son. Do your math better. But he's gonna come up here and physically confront me. That was me. That was a jerk off motion, by the way, in case you couldn't see it. But on the other hand, he's intimating that he's going to sue me for defamation. So why, if you're going to take physical action for an alleged wrong, tortious interference with business relations, stalking, harassment, whatever, he's going to bring legal action on the one hand, but physical action on the other hand? Like, why not sue not just for defamation, but also sue for tortious interference with business relations, or tortious interference with potential contracts or clients or whatever? Why not sue for both that and the defamation? If you're going to file a lawsuit, if you're going to pay the $435 and write a complaint, why not do both? If you're going to come up here and kick my ass, why not come up here and kick my ass for both? It's weird. It's really weird. Another thing that's really weird, Josh pointed out, he hasn't gone through the entire video yet. Josh being Stoned Vet, by the way. Platoon Hard Drive, he goes by different names because he's a bit... But anyway, so Josh was going through his video and pointed out that twice, not once, but twice during the live stream at the biker bar, but twice at the biker bar, he said that he was injured in boot camp. And again, Ehline struggles with this, but words have meaning. And boot camp is not School of Infantry. School of Infantry is after boot camp. Boot camp is done. You've graduated from boot camp. I don't know the technical terms. That's why I say graduated. You pass boot camp, whatever it is, whatever militaryism it is, you get through boot camp successfully, and then you're sent to another school of infantry for training. At least that's my understanding of it, not having served. I don't really know. I'm sure that Josh can clarify it. I'm sure he will clarify it. But if you get injured at boot camp, that means you didn't get injured at School of Infantry, because they're two different things. Boot camp, School of Infantry, two different things. Josh, correct me if I'm wrong. So, Ehline, what is it? Do you just not understand the meaning of the words that you use ever? Or were you injured in boot camp? Did you make it through boot camp? How about you show your DD-214? Now, I don't really care. I don't think that you being a Marine enhances or detracts from you being an attorney now. I'm sure lots of Marines went on to be successful attorneys. I'm sure lots of Marines didn't go on to be successful attorneys. It is an irrelevancy to me. But, bitch, why you lying? Thanks for watching. Have a great day.